Just checking. Awesome. Right. So, hi everyone. Firstly, just want to say thanks so much to the conference organisers today for putting on such a fantastic programme and giving me the opportunity to be here. I am conscious of our time constraints this morning, so I'm just going to get stuck right in. My research project does have quite a lengthy title there in this paper, but essentially I have now discovered I'm interested in looking at colonialism in institutions and institutional rules, and particularly what is the impact of colonialism when present in constitutional rules in the context of language rights. So if I can just move this on. So we could cast our minds back to 2019, particularly that 2019-2022 time frame. We can see that there has been legislative intervention by way of the UK Parliament in the context of human rights in the North, particularly with regards to abortion and LGBTQI rights. And this was seen as very significant at the time because there is a constitutional convention called the Sewell Convention, and the Sewell Convention stipulates that there will not be essentially any legislative movement from the UK Parliament without the consent of the devolved institutions. So essentially, why we see this movement at this time for these categories of human rights. And during that time frame, there was ongoing debate about devolution, how to protect the devolved arrangements and devolved competencies against international obligations on the British government to protect and promote human rights. In that debate, ultimately, the argument around international law came through, and that's why we have seen the recent legislative change, which is, as I say, ongoing. But why do we not see it in the context of Irish language rights, particularly when it's apparent in the context of the Irish language in the North? There are numerous domestic, political and legal requirements and provisions imposed not just on the devolved institutions themselves, but also in the context of the British government. So we see then this disparity, not just of rights protections, but also in a sense of intervention when it's apparent those rights have not been protected or promoted or advanced as they should have done in law. So my PhD is looking at how have really political interpretations and applications of those constitutional conventions, both historic and contemporary, have had on the Irish language in the North since partition. And in so doing, I've come across in the last couple of years of my PhD this real sense of the presence of colonialism. And in so doing, I have termed constitutional colonialism, whereby it's not just no longer about the political application and the political interpretation of these conventions, it's what's the ground root source? Why do we have the politicalisation of those constitutional rules in the context of the Irish language? And I would argue it's essentially because we have seen a sense of othering of the Irish identity, including the Irish language, against that of the British identity because of partition. Now, again, like I said, I'm conscious of time, but I think it's important just to run through some of the source material on this. When I talk about conventions, because I'm a legal scholar, but I'm also a legislative scholar, there is this sense of trying to understand what they actually are. And unfortunately, scholarship is not quite agreed upon this. The classical definition says that conventions are rules that regulate conduct. But we have seen that essentially how and when conventions are used is subjective. There is a united body of scholarship on that. And in fact, it's exceptionally dependent on the political actors themselves as to when to recognise and invoke conventions. And why is that important? Well, essentially, for me, it's skewed power dynamics. If you have power holders such as the British government essentially picking and choosing when to recognise the Sewell Convention, for example, to step in and legislate for human rights reform in Northern Ireland, why do we then have a hierarchy of rights in which they choose to ignore the Sewell Convention, but equally categories of rights when they will not step in and legislate? Why is it important in the parliamentary context? It's a form of parliamentary law, and essentially when conventions are recognised, when there is that sense of the political interpretation application, there are far-reaching ramifications. People always tend to think about the output in terms of legislation. It's actually starting in the chamber itself. When these conventions are invoked, you can see question time being stopped, you can see debates being stopped, you can see a refusal to be held to account. In the context of Northern Ireland and the Irish language, we have seen conventions invoked to basically say that there cannot be any further discussion. It's under the purview of the devolved institutions in the North, and that's particularly problematic when we have that body of international law that imposes obligations on the British government, but in the absence of the devolved institutions in the North, there's that vacuum of accountability, not just necessarily progression of human rights. And then lastly, and I promise this is the last bit of theoretical context, I just think it's important in that colonialisation and decolonialisation aspect. In my research, I am using a framework, what I've called critical legislative studies. And in that, I'm trying to argue that legislative rules and procedure and how it relates to the Constitution, it's embedded with social biases. And that therefore means when those rules are invoked or when they're not invoked really relies on your connections with those social biases. In some, there's no distinction between law and politics, but equally, this is the chamber where you might see competing political identities, competing nationalities, interpretations of what constitutes identity and cultural rights come to the fore. It's particularly apparent in the human rights context. There is critical scholarship that denotes the whole purpose of the institution should be to protect and defend human rights, but when that does not happen because of that reliance on affirming political affiliations or social interests, what does that mean for those whose rights should be guaranteed by these institutions? So for this presentation, I've drawn on a paper I had written and whereby I had trawled through Hansard in all its glory to try to understand when conventions have been invoked. And like I said at the start of this presentation, it's no longer just about when conventions are invoked, it's what's the root source. And for me, we have to go back to othering. This is a quotation from a debate that was held in 1948. And it was by a Unionist MP, Professor Savroy. And in this debate, there was discussions about war criminals and the fleeing of war criminals into the jurisdiction of the 26 counties. But in this debate, this MP talked about the differences between the North and South of Ireland. He compared it to Canada, particularly in the context of difference of languages. Different in outlook, different in language, different in race, and different in religion. And this is where we start to see this distinction between the North as its own category of identity, but using the context of the Irish language to make it so. We ask that our status, which has been accorded to us and affirmed to us over and over again by the British government, shall be maintained. There's that real sense of the northern part of the island in which the Irish identity, including the language, is not present. If we go forward then to the civil rights movement, in fact, I'll quickly interject to say, in the 40s and the 50s, there's still this connotation of the Irish language as being something connected to the war. And there was a lot of scapegoating, but equally there's a sense of trying to cause fear already with the language. There were different debates I found which compared the developments around protection of the Irish language in the 26 counties to this sense of the impact it would have on Protestant unionists who wanted perhaps to have a job or could lose their job if they did not speak Irish. That othering really comes to the fore during the time of the civil rights movement. At that time, there was already the debate about the impact of the lack of progression, or rather the deliberate violation of human rights in the North. What role would the British government of the day have in trying to correct that? Section 75 of the Government Ireland Act 1920 essentially affirmed parliamentary sovereignty. It said that the British government could legislate in what was then the Northern Irish institutions. That section had never been invoked, so the civil rights movement constantly tried to invoke Section 75. This is where we see a historic convention, and this is where we see the impact, as I said, of parliamentary law, where you can see debate curtailed and the lack of accountability. This is just a sample, but there was a rule which said as soon as there was trying to be any discussion in Northern Ireland, including minority language rights or minority rights in general, the Speaker would affirm this convention to basically say it's under the purview of the Northern Ireland Government and Parliament. We cannot discuss it. Not even we cannot debate it, we can't intervene, it cannot simply be discussed. That therefore meant that the British government couldn't be held to account under the law of Section 75. This is simply another contribution which was taking place during the time of the Civil Rights Movement, where it was on a specific debate about rights of minorities, in which that sense of the Irish citizen being othered and being marginalised in a northern state was invoked. When the debate was put to the representative of the British government in the House of Lords, he invoked the historic convention to say, you can debate this matter, I cannot respond to this matter. Her Majesty's government essentially is not accountable for this matter. And I will quickly forward to the contemporary aspect of this. I'm sure we all know in the room the role of the St Andrews Agreement in 2006 around protection and promotion of the Irish language and the imposition, or rather, the obligations it imposed, both on the British government and the devolved institutions. The St Andrews Agreement became really prominent during that time frame, 2017 to 2020, and arguably ongoing, around the responsibilities to protect and promote Irish language rights. This is where we see SUAL, however, come to the fore. While SUAL was invoked in those case studies I mentioned at the start of my presentation, abortion and LGBTQI rights, eventually the Theresa May government in particular took a step back and accepted the argument of international law. In the context of the Irish language, that did not happen. The SUAL Convention was repeatedly recognised or affirmed within both chambers of the UK Parliament. This sense of it's a devolved matter, we simply cannot intervene, we will not intervene. And therefore we see that disparity again in when the British government chooses to intervene and what rights categories it intervenes on. And I will just fast forward here to the recent sense of legislative intervention and how have we come to this place. Does this not simply completely reject all my argument outright? I would argue the Identity and Language Bill doesn't. We still see within this Act that sense of othering, the lack of space and place being given to the Irish language, a sense of trying to shoehorn many matters into one piece of legislation. And what's very interesting about this piece of legislation is that we didn't see any affirmation of the SUAL Convention. The argument was that the Parliament had endorsed this by virtue of accepting the 2020 agreement made by political parties here, which simply to me makes no sense. And also, therefore, I leave you with that sense of, if we accept there's political interpretations and applications of conventions, it's grounded in that sense of othering, particularly in the context of the Irish identity. This continues that problematic nature because we're still uncertain as when we will see intervention, what does it actually look like, and most importantly, does it actually deliver tangible results for the protection and promotion of Irish language rights. So thank you very much for your attention.